Hello, everybody. So good to see you guys. Hi, Auntie M. And crazy old Rexy. And Rocky Lennon, sweetie. That's what we do around here. When YouTube doesn't take care of us, we take care of us. That's why we created the whole Discord notification setup that we've got. I'm glad that you won't be late anymore. I'm so happy you're here. Yeah, see? And it's a good way to get a hold of me because I know you like sending me clips on Instagram, and I am sorry. I am the worst Instagram checker of anyone. I don't have room on my phone for all of the apps. That's the problem. So I can't access a lot of the apps without actually logging in through the web page on my phone through the web browser. And that just gets to be a little much because I'm not getting the notifications of it. Otherwise, my phone is never going to stop dinging. So it's kind of a, log in as you go kind of thing. So that gets a little difficult to keep up on. I'm sorry. But yeah, if you send me suggestions through Discord, then it's a lot easier for me to see them. We don't have exactly a grumpy judge tonight. I am working on grumpy judges, but what we have tonight is actually a whole bunch of cases strung together. What appears to only be a little over an hour worth of a docket is about 9 to 10 or more-ish hours of me sitting through finding anything worth watching. So I know it doesn't seem like much, but I spent the entire day on the computer to make this tonight. So, but I will find a grumpy judge soon. I think I need to go back to Cass County because that judge he was pointedly grumpy. Or Judge Schaefer's really always good about being grumpy. I like him too. Hello, Shane. Did I fall asleep? When? No, I'm here, silly. Y'all can see me, right? Hey, Brian Boggs. Happy Sunday to you. Hi, Chinny. I know you do. I do it so that I can hang out with you guys. Ooh, in the big city? Wow. Hi, Ava. Did you just notice that I was talking to all your friends? Did you notice I was talking to all of your friends? And you wanted to be a part of this, huh? Or did you just want your treats? Because you realize they're not in your mouth. Okay, I'm coming. My goodness. What? Are you okay now? You got a little too excited, huh? A little too excited, a little too quickly. Go get a drink. Come back after you're hydrated. You want me to give you Blue Buffalo biscuits when you're not even getting a drink. Her favorite thing in the world, Joe. Oh, it really? Those jerks. How dare they? Hi, beautiful. Who's the prettiest girl? She got one of her best bully sticks bones today, the marrow bones. I gave it to her outside after the rain stopped. And I left her out with it for a little while, and the rain started back up with her outside chewing on her bone. She didn't care, though. She had a bone. She had a bone to pick with me. Hi. Wow. Hi, Mish. Welcome. Ava says hello. Yeah, she's such a good girl. Chooks will eat anything. They'll even eat their own eggs. So, okay, my goodness. All right, I'm putting them away, you guys. I'm putting them away. She's going to be mad at me. Billy's so mad at me that he gave me an I love you this long on my leg. I got a big old bandage on it. Yep. I was not impressed. He was well chuffed with himself. I was not. All right, guys. So we're going to start off with Judge Wade Mercer. And then I've got a little nugget of love coming from Arizona. But unfortunately, they're having a lot of technical difficulties lately. And I mean a lot of technical difficulties. So the only thing that you can really see is the judge. So, which is, it's okay. Because all you need to do is hear. From there, I have one or two with Judge Sylvester. He is another one of my guilty little pleasures. There's hardly ever anything super good on his channel, but I love watching him, and I think he's absolutely gorgeous. And then we go into Judge Brantley Clark of Florida. So start with Florida, end with Florida. You've got to be kidding me. Make sure that you didn't get logged out. That happened to somebody once before too, where they didn't realize that YouTube logged them out. But you know I really appreciate you. And if you can't give them, whether it's by your choice or YouTube's choice, just know I still love you. And so does Billy. Can y'all hear Billy? Or you just think I'm making weird faces? He's something going on with Billy. Well, yeah, they have Florida man for a reason. No. Actually, the cases in Florida could happen anywhere. They're just more open about reporting them. All right. It's being putsy. I swear. I'm clicking.
Danzy. Mr. Danzy, good morning. Mr. Danzy, you're here for the charge of driving while license suspended or revoked. Mr. Danzy, there is probable cause in the complaint. And Mr. McDaniel, anything else I need to be aware of on behalf of Mr. Danzy?
No, Your Honor.
Ms. Bremer.
Your Honor, the state requests a reasonable bond and that he not be permitted to drive.
without a driver's license.
Thank you. Mr. Danzy, given the fact that you allegedly got the same charge except the civil version within the last week or so, your bond's going to be $3,500 cash or surety with a condition not to drive a motor vehicle unless you get a valid license. If you get a valid license, you can drive. But if you get caught driving without a license again, then that's going to violate your bond and you're going to go to jail with no bond. Mr. Danzy, I know that you have a question and I'm glad to answer your question, but don't talk about what you've been accused of because we are being recorded and I want you to talk to the attorney in private before you say something that's going to hurt yourself. Do you have any questions?
It said that you said that I've been charged twice or whatever.
The complaint says that. Let me tell you what it says. Deputy Gramling advised me that he had issued the same driver a verbal warning. Sorry, it was verbal warning, not charged. A verbal warning for the driving license suspended approximately a week prior. So law enforcement saying that you were issued a verbal warning a week prior. And Mr. McDaniel, I didn't catch that. I thought he had been charged. That
We've got two in 2022. So I thought that's what you were referring to. With the, I saw two unknowingly, and this will be his third, no matter what. So,
well, okay, let me check that because what system were you looking on when you saw that?
CCIS. I saw an unknowingly in 22 and a knowingly in 22.
Okay, give me a second because this David's system only showed one.
That's all I remember. But I mean,
and I thought he had one, and he had one in the pipeline, but it looks like he had one, and the most recent one was just a warning. So that my recommended offer, his David system only shows one.
Okay.
And it shows one in, let's see where it was at, Bay County in 22.
Yes. Sir.
So, Mr. McDaniel, do you want me to check CCIS? It may be a probation offer. If he knows he doesn't want to take probation, then we'll just set the bond and be done with it. But if he wants to take probation, then I need to look and see if it's right. If he has a prior other than the one at 22.
He would take probation, Your Honor. And they may have been one that it may have been downgraded because they were pretty close. I thought the unknowingly and the knowing, and he may have not have paid it yet. That might be why it's not on the system. I mean, so as soon as he pays that fine, it's going to go on his record. I think that's
You're absolutely right.
Yes.
Mr. Danzy, we're trying to keep you from getting a 5-year suspension. Mr. McDaniel's probably explained to you, if you get 3 within 5 years, that's going to be a 5-year suspension. So we don't want that to happen. Now, if it happens, it happens, but we're trying to at least let you know the consequences of your plea before you enter it.
Yes, sir. I mean,
Judge Mercer, let me break in here for a second because the cop got the wrong date of birth on the complaint. I just went and looked at his driver's license. His date of birth should be 9/22/1990.
Okay. Do you know if let's see which one I pulled up on David.
Well, the criminal history shows the correct.
Okay. The David system I pulled up was right. So Mr. McDaniel, I bet we put in the law enforcement information, or you put in the law enforcement information as I would have for the date of birth. There may be more than one Dustin Danzy in Florida. So I'm looking at CCIS now. It's a different system. It shows one in 22 in Calhoun County. Mr. McDaniel, you're exactly right. It shows one being charged in Calhoun that is in collections. But let's check the date of birth on it.
As soon as he pays that fine, he goes in there and tries to get his license fixed and pays that fine, it's going to go on his record.
Let me check the date of birth on that one. You ever got a ticket in Calhoun County that you're aware of, Mr. Danzy?
Yes, sir, I did. Yes, sir, I did. I did get one in Calhoun County. Yes, sir. But I've already done paid it. And I mean, it was an unknowingly about my driving while suspended.
So, Mr. McDaniel, if he has an unknowingly for habitual purposes, that counts as a prior, right?
Correct.
Okay. So, Ms. Bremer, based on our understanding, I think if he enters this plea to DWLSR, it is going to result in a 5-year suspension because he'll have 3 within 5 years, but he does not have one from last week that I thought he had. It turned out to be a warning. So does the state have a problem with the probation and no valid?
No, Your Honor, no objection.
Mr. McDaniel, if your client wants to do that, we can resolve it today. Otherwise, I'm glad to set him a bond.
Your Honor, we're going to plead of no contest to the charge of no valid driver's license. You understand that he'll be placed on 6 months probation, no early termination. There'll be a $400 fine, and he's going to waive his right to a jury trial and call witnesses.
Mr. Bremer, is that agreeable with the state? Mr. Danzy, did you hear that agreement?
Yes, sir. Yes, sir.
Mr. Danzy, I don't know that Mr. McDowell, he may have said this. I was reading something when he spoke part of that time, but part of your probation will be that you cannot drive a motor vehicle unless you get a valid license. You understand?
Yes, sir. Yes, sir.
And knowing all of that, is this the plea you would like to enter?
Yes, sir.
Mr. Danzy, I'm going to accept your plea of no contest to the amended charge of no valid driver's license, withhold adjudication of guilt, place you on probation for 6 months. Court costs and fines will be imposed amount of $400. Do not drive a motor vehicle unless you get a valid driver's license. The no early term, was that, did he say that?
Yes, sir.
Okay, I didn't even catch that. Mr. Danzy, so you got 6 months probation, no early term. What we're going to do, sir, is you're going to get to use the phone to set up transportation, Mr. Danzy. Then you're going to be brought to the courthouse because that's where the probation office is at. When you get here, you'll meet with the probation officer, either Mr. Goodson or Mr. Ham. One of those gentlemen will go over the probation with you. They'll answer any questions you have about it. They'll give you a copy of all the rules in writing, and then you'll be free to leave. So if you call friends or family, you can tell them that you can be picked up in about a half hour at the county probation office in Mariana. Any questions?
No, sir. That's it. Thank you.
Have a good day, sir. I used to have hair just like Mr. Danzy. Same color and everything.
So if you've ever wondered what Judge Wade Mercer looked like in his younger days, apparently it was just like Mr. Dancy.
Dad, Kabas. Good morning,
Yes,
sir.
sir.
You're here because you've been accused of violating the terms of your pretrial intervention. Mr. Kabas, the warrant is a no bond warrant. Please listen to Mr. McDaniel. He has some additional information I think he wants to make me aware of, and perhaps Mr. Goodson also.
Yeah, Mr. Goodson, everybody.
Yes.
Okay, so Mr. Goodson, I mean, you can correct me and if we're totally wrong on this, but Mr. Kabas is telling me that he had done everything in his his driving class he did online, and he showed it with you on the phone, and you were waiting for he was waiting for the certificate to come back through. He was going to turn it into you, but he never did get it. I guess he thought that after that 3 months that, with early termination, that he was completed it. And if you know something different, I mean, please inform me.
No, he did. He checked in when he got put on PTI was November the 7th, 23. He checked in for the 3 months as he was supposed to. He paid his fine in full. He had paid the COS up for 3 months. The last contact I had with him was January 25th, and he told me he was going to bring in the certificate, and I put in the notes, as soon as he brings in the certificate, we will send the case back on February 7th, which would have been the 3 month mark, to Ms. Bremer for possible no information. I never heard back from Mr. Kabas. He never brought the certificate in, so his time was fixing to expire. So we did an affidavit and a warrant. So he did comply with everything. He checked in 3 months, but I never got a copy of the certificate.
I understand. That's what he was telling me also. So Mr. Kabas, did something happen with you getting the certificate, or?
They never sent my certificate.
Speak up.
When I took the class, they said it would take about 2 to 3 weeks for them to send the certificate. And then I checked my mail and I never got the certificate mailed to me. But I have proof that I took the class.
Are you still a student at Chipola, or?
Yes, sir. I'm going to FSU coming up August.
It's always going to FSU?
Yes, sir.
Okay, and I guess Mr. Stacy, Mr. Goodson, did you see his completion on this telephone, I guess, his app or whatever?
I can't remember that. Mr. McDaniel, I mean, he could have possibly showed me something but that was January 25th. So I can't say if I did or I didn't. I just put in the notes that he was going to bring in the certificate. That's what I put in my notes.
And Your Honor, I think we're going to go ahead and just, do whatever the court wants to do with the case, you know what I mean? And, if it means admitting, because he did make a mistake on it. I don't think it was purposely. I think he was understanding that after 3 months that it was going to be terminated. He clearly forgot to find that certificate and bring it in though, but we leave it up to the court's discretion to do whatever's appropriate.
Is forgot really the correct word for that? I think it was kind of more like he blew it off because he figured, I showed him. and my time's almost up. So if they didn't, I didn't get it. So no big deal. He knows. I think that's probably more the scenario.
You want to enter that plea of no contest to the court?
So I guess my one question is, if you didn't get a certificate, why didn't you report back in the next month and say, I don't have the certificate still? Or why didn't you call Mr. Goodson and say, I don't have the certificate. They haven't sent it to me yet. What do I need to do? I don't understand that part, Mr. Kabas.
Yes, sir. I apologize. It's because whenever I showed him on the phone, because I told him that I took the class, and the only thing I was waiting for my certificate, and I thought because of that, I waited for my certificate to come, and thinking because I already took the class, I didn't have to bring back the certificate, knowing that I showed him on the phone, but it was a I apologize.
You're telling me a couple of different things, though. You're saying that you were waiting on the certificate, but you're also saying you thought you were done with it. So why would you be waiting if you thought you were done? What difference does the certificate even make if you'd already showed it to him on the phone, if you thought that was sufficient?
Because I showed him on the phone, and I told him that the actual certificate won't be mailed till 2 to 3 weeks. And then whenever I checked my mailbox, I never got the certificate. Like, they never mailed it to me.
Were you under the impression when you left that day that you did not have to come back because you had showed him on the phone?
No, sir.
Okay, so why didn't you come back the next month then?
Because I thought that showing him on the phone would.
I just asked you a very simple question. When you left that day, were you under the impression that when you showed him that on the phone, even though he didn't have a certificate, that you did not have to come back and report anymore? Was that your understanding?
Yes, sir.
Okay, how did you get that understanding? Where did you get that understanding from? Did somebody tell you that? Did Mr. Goodson tell you that, or what made you think that?
I think Mr. Goodson told him we're good, something of that nature, when he come in and checked in and shut him down the phone, and he interpreted that to mean he didn't have to come back. And I don't think that's what Mr. Goodson meant when he said we're good. You're good to go. I think that's what he told me earlier. He told me I was good to go when he showed him on the phone, and I said, but you didn't get a letter that said that it was terminated. And he said, no, I didn't. And I think he misunderstood his language when he said you're good to go. I think he meant that he was good to go for that day, and we'll see him next month. But I think he interpreted it.
I appreciate that, Mr. McDaniel, but you or I weren't there. I don't have no idea what Mr. Goodson said. And
I don't know what I said either. My notes say this. On January 25th, 2024, subject N will bring in certificate for 4-hour class. And I will send case back on February 7th to 23 if I get the certificate. That's what I put in my case notes. So that's what I put in there.
Ms. Bremer, what's your thoughts?
Based on what's in the file, it does not appear that there was a mutual understanding that the defendant was finished with the CTI, but I do understand there could be some confusion.
Yeah, I don't never have Mr. Goodson accused of not being clear. Maybe once or twice in 25 years. I feel like he's pretty clear. I think the solution is to put him back on PTI, let him finish his full term and not early term, and exclude the months that he didn't report. Let him back out, not reward him for not doing what he didn't do, but at the same time, not let him off any earlier than the full 6 months. So when was the warrant issued? Well, this was a recent warrant. So y'all didn't report it. Y'all didn't do a warrant for months after he didn't do anything.
I mean, actually, his time expired.
Because y'all waited so long to do a warrant. So he's supposed to bring it in February. He's supposed to bring it in February, and y'all didn't do a warrant until May.
I'm not going to have any objection, Your Honor, to 3 more months of supervision and to complete that class and give them a certificate of it. I think that's extremely reasonable. I'm not going to object to it.
Can I do that legally? What degree misdemeanor is it?
I think if I don't
reckless
object
driving, you can do 9 months, can't you, on reckless driving? Yeah, reckless driving is a hybrid. You can do 9 months supervision. So I think legally I can do that. So Ms. Bremer, what do you think about just extending the supervision by 3 months from today? No early termination. It will still be a PTI. That way he won't have a conviction on his record if he completes everything, and he'll get out of jail and just complete reporting for the next 3 months, including finishing any previously imposed conditions, such as either doing the school again, if you can't get a certificate, or providing a certificate, not a picture of a certificate that you completed the program. How does that sound, Mr. McDaniel?
That's perfectly acceptable, Your Honor.
Mr. Kabas, is that what you want to do?
Yes, sir.
What we're gonna do is we're gonna show your case extended then for 3 months from today. Same conditions as before, not adding anything to it, but you've got to complete any uncompleted conditions from previously. So that's a condition that you have not completed. So you've got to complete it. And you've also got to report in for the next 3 months. As long as you do that, the state's going to honor their original agreement with you and dismiss this case. There doesn't need to be any more misunderstandings. Mr. Kabas, any questions?
No, sir.
Do you need him to report when he gets out of jail?
He got lucky.
Okay, so what we're gonna do is ask the jail just to bring you, when they bring the conditional releases, you'll get to use the phone before you leave the court, before you leave the jail. And you can tell your friends or family that you can be picked up at the courthouse in roughly a half hour. And then you'll be back on conditional release, PTI and conditional release like you were before. Just make sure you don't have any uncertainty and do the conditions you've got to do so that you can get this thing behind you and it won't affect your future, okay?
Yes, Your Honor.
All right, any questions?
No, sir. Thank you.
All right. Yes, sir. We'll see you in about 30 minutes at the courthouse.
Hi, sir. Can I get your full name?
Now we head to Arizona. And like I said, we'll only be able to see the judge or part of her for this time. But it's worth it.
Okay, Mr. Sosa, you are here on some warrants out of Tucson City Court. And I show that you're being held on a probation hold right now. So I'm going to order that you be held on a $500 cash bond on your city court matters. I will appoint the city public defender to represent you. And you will be seen by video on June 3rd at 1:45 in the afternoon with Judge Maldonado. Do you understand?
No. I don't know what any of this means. I don't know legal stuff. How do I get free? How do I get rid of my legal issues? I'm tired. I don't know what I'm supposed to do.
Okay, well, you're going to be in custody and you're going to go to court. You'll go to Superior Court regarding your probation case, and you'll go to city court regarding these cases, and you'll get more information then,
I tried
okay?
going to probation. They didn't show up at the time that it was supposed to be, the appointment. And then I
Right.
went when they said to go, and nobody was returning my phone calls. This is bullshit.
All right, talk to your attorney about that, sir. You're excused.
Whatever, go fuck yourself.
All right, Sosa. Don't be throwing stuff on the computer.
And if you didn't catch that at the end, I'm assuming that was they always have a defense attorney in the room with the person. And, you know, he said, all right, Sosa, don't be throwing stuff. So I guess Sosa got confused with being Sousa for a moment.
And you're Tammy Rash?
Yes.
Ms. Rash, you're here today in case number 2024 CR 42, where you have been charged with several crimes, and I'm going to go over those with you right now, okay?
Okay.
In count 1, you've been charged with criminal damage to property.
And what did you say, count 1?
Criminal damage.
Okay.
And this claims that on or about May 19th of this year, you substantially impaired or destroyed or defaced the use of property, which in this case was antique statues, decorations, potted plants, and candles to the extent of at least $1,000, but less than $25,000. This is a severity level 9 felony, and it's punishable by up to 17 months in the state penitentiary and a fine of up to $100,000. Now, those are maximum penalties.
Okay.
And in count 2, you're charged with misdemeanor criminal damage to property from that same date of May 19th. And this claims that you damaged or destroyed plants and landscaping to the extent of less than $1,000 that belong to the Kingman Christian Church. And this is a Class B misdemeanor, and it's punishable by up to 6 months in the county jail and a fine of $1,000. And both these charges claims that you didn't have the consent to destroy this property.
I did.
Now, in count 3, you're charged with disorderly conduct, claiming that you alarmed, angered, or disturbed others, or provoked an assault or other breach of the peace by using fighting words or engaging in noisy conduct tending to reasonably arouse alarm, anger, or resentment in others. This is a Class C misdemeanor. It's punishable by up to 30 days in the county jail and a fine of up to $500. Now, I'm not asking you if you did these, but I'm asking you if you understand these charges.
Yes, I do understand.
Now, they're only allegations. You have the right to have a trial on this matter where the state has to prove beyond a reasonable doubt that you committed these offenses, and you have the right to have legal counsel. And if you can't afford an attorney, one will be appointed to represent you. Do you understand that?
Yes, sir.
Now, do you plan on hiring your own attorney, or do you need the court to appoint you one?
No, I don't need either. I think I can represent myself by if they ask me a question, I can explain what happened. I don't think the Lord's with me, so he should be able to guide me through.
Okay.
The Lord's with you after you defaced and destroyed a whole bunch of property and antiques and, you know, plants and landscaping at a church. And you're gonna hold with that one. I agree, he is. But that probably should have been the last place that you destroyed.
Don't.
Okay.
If somebody says something I didn't do, then I'll have the right to say I didn't do that right and explain why.
Yes, absolutely. In fact, you're presumed not guilty. But now, if you ever want legal counsel, I can appoint you an attorney to represent you, okay?
Okay. Well,
And
maybe I
then,
can do that.
excuse me?
Maybe I could do that.
Okay, are you currently employed?
No, I'm a disabled veteran.
Okay, so what I'm going to do is I'm going to appoint Mandy Stevenson to represent you. And that way you'll have somebody you can talk to about this case, and she can help you work out some of the particulars on this and some of the legal things that you might not understand, okay?
Okay.
And then I'm going to set you for your next court hearing next Thursday on May 30th at 9:30 in the morning. Do you have any questions?
Yes, can I get out today?
Okay, now these are pretty serious charges, and you don't live here locally, I understand.
Well, I was living in Wichita, but I'm camping at the lake. I was just
Okay.
right outside of town here.
Okay,
I've never not showed up in court.
I tell you what, I can take that up at any time, but I'm not going to take that up today. But I want you to talk to your attorney. We're going to send you her contact information, and you talk to her, and she might be able to help you work that out. Okay. Okay.
Okay.
And if nothing else happens, I'll see you next week.
Well, I can bail out. I have the money, but they're not, you have to have somebody co-sign it when you're alone or by yourself. I can't. I mean, I have the money to put up to bail out.
Okay.
But I can't.
Well, we're going to give you, I tell you what, I'll give you your attorney's contact information. She can help you with that. Okay.
Okay.
All right. And we might be able to take this up sooner than next Thursday.
Okay.
Okay. So, well, thank you very much. And I'll see you next week.
Okay. Thank you, Judge.
Uh-huh.
I can still call cell phone now.
How you doing, Your Honor?
Are you Kevin Ferguson?
Yes, sir.
Mr. Ferguson, you're here today in case number 2024 CR 44, where you have been charged with one count of being a pedestrian under the influence of alcohol or drugs. This claims that on or about May 21st of this year, You did unlawfully walk or be upon a highway and not on a sidewalk while under the influence of alcohol or drugs to a degree that rendered you a hazard. This is an unclassified misdemeanor and it's punishable by up to 30 days in the county jail and a fine of up to $500. Do you understand what you've been charged with and the possible penalty?
Yeah.
Now, this is only an allegation. You have the right to have a trial on this matter where the state has to prove beyond a reasonable doubt that you committed this offense, and you have the right to have legal counsel. If you can't afford an attorney, one will be appointed to represent you. What we're here today is to figure out what you'd like to do about legal counsel. Do you plan on hiring an attorney, or do you need me to appoint you one?
I'm gonna need a plan.
Okay. Are you currently employed?
Not yet, sir.
Okay. And so I'm going to find that you qualify for a court-appointed attorney. Have you ever been in municipal court here in Kingman?
Actually, I had court the 23rd, which was this morning in Pride.
Okay, but not no municipal court with the city of Kingman.
No, I have not.
Okay. Okay, good. So I'm going to appoint Cody Smith to represent you, and we'll be sure you get his contact information, and I'm going to set you for your next court hearing next Thursday, May 30th at 1:30 in the afternoon, and then you can be sure and contact your attorney. And I'm also going to modify your bond to a $500 OR bond. And we'll try to get that paperwork over here in the next few minutes so you can get out today, okay?
Thank you, Your Honor.
As a condition of your bond, I'm going to require that you not consume any alcohol or drugs while you're on bond, okay?
Yes, Your Honor.
And
I'm
if you do,
getting ready to go get clean permanently.
okay, well, good. I wish you all the best in that. But while you're on bond, if they find you intoxicated or that you've been consuming drugs or alcohol, you can have your bond revoked. Okay.
Yes, Your Honor.
And be sure and keep in touch. Get in touch with your attorney and keep in touch with your
Okay.
attorney.
Would you have a pen so I can write his number down?
And we'll get you the paperwork here as soon as we can. Okay.
All right. Thank you, Your Honor.
Okay. Thank you very much.
Mr. Bollinger? Your Honor, we have Edward Sanders in case number 21-1506. Your Honor, I filed a 3.850 motion just for the court. The state had responded that we did not state in the motion the relief requested. So what I did is I amended that motion. I had talked to Mr. Sullivan when that come back, and we had filed that this morning, just requesting the relief that we wanted so that we could check all the boxes.
All right, you guys. So I don't remember if it's the very first one or not, but we're back to Judge Brantley in Florida. So we've come full circle. And somewhere in this lineup is, I believe it's this first one here. It has to be, yeah. Where the investigator is crooked. And all of the other cases that had been convicted because of his testimony had been overturned. And this one somehow did not get included in that whole pile of mess. And so now this is a motion to overturn the conviction and basically force the state to retry the case without the testimony from that investigator who has been fired.
Your Honor, I'm sure you've read the motion. I'd like to just go ahead, and Mr. Shepherd is here. I can go ahead and question him and make this pretty quick.
Okay. And Madam Clerk, if you'll swear Mr. Shepherd in.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
You are Rusty Shepherd, an attorney here in Bay County, correct?
Yes, sir.
And you represented Mr. Sanders in this case that we're here for today on a 3850. I believe it was a trafficking case.
Yes, sir.
Okay. Did you file a motion to suppress physical evidence in that case?
I did.
And was that heard before Judge Clark?
Yes, sir.
Was the basis of that motion that the confidential informant was not disclosed, thus none of the information could be corroborated, and that the CI had not been established as a credible informant?
Yes.
Okay. And so basically, this boiled down to Investigator Williams' credibility before the court.
Absolutely.
Okay. Was Investigator Williams the only one that testified at that hearing?
That is my recollection.
Okay.
We
And
would have
was
loved
this
for the
motion-
confidential informant to be there, but under the rules, we couldn't get to the confidential informant.
And was the motion denied?
It was.
Do you remember the court's holding on that?
I don't remember. I do not recall specifically. I just remember it was denied.
Basically, the judge had to determine the veracity, reliability, and basis of knowledge had been established by the CI's prior work, and then the judge denied that.
Correct. And
denied your motion.
Yes. Based upon Investigator Williams' testimony at the hearing. I think he had said that there were several cases that he had made. They had led to arrests. They were currently under prosecution. My recollection is that, he was the only one who testified at the hearing. So obviously it was based on his credibility.
Okay. And based on this denial, Mr. Sanders had to basically accept a plea on this case.
Correct.
Okay. With Investigator Williams, did this involve some type of internal investigation and any sanctioning on him?
I mean, we later found that Investigator Williams is, his credibility is zero. I mean, he's been fired from the sheriff's office.
Objection, Your Honor.
What's the objection?
His opinion about his credibility.
I'm gonna overrule the objection.
He has none. He has no credibility. He lied. I've seen him lie in court. He's perjured himself.
Objection, Your
He
Honor.
has no credibility.
Overruled.
Was this unknown to you at the time of Mr. Sanders' case, this internal investigation?
Unfortunately, yes.
Okay. Have you had any other cases come back to court because of Investigator Williams' problems?
So two of our clients, Mr. Sanders somehow, I don't know that we ever found out who the confidential informant was in Mr. Sanders' case. Otherwise, there would have been three. But two of ours came back. One was released from jail. The other was his sentence was vacated. He came back and pled to time served. And there were, I believe, seven clients or seven individuals who were represented by the public defender's office who also came back. So I'm not sure how Mr. Sanders got lost in the shuffle. My apologies to Mr. Sanders. Certainly, he doesn't, wish we would have known about the investigator's credibility at the time.
Had you known about Investigator Williams' issues, would that have directly impacted Mr. Sanders' case and how you represented him?
Absolutely. Would have it allowed me? Yes, sir. Absolutely.
Would it affected your advice as to whether he should accept a plea or not?
Absolutely. Yes, sir.
Would it affected would it affected your ways of how you questioned Investigator Williams at the motion hearing
Absolutely.
and the motion to suppress?
How I argued it? Absolutely.
And basically as to your whole case with Mr. Sanders, correct?
It was based on Investigator Williams.
Did you ever learn who the confidential informant was in Mr. Sanders' case?
I did not. And in fact, actually, to this day, I'm not sure. Oh, I mean, you would know that, but.
And if you recall, do you remember Mr. Sanders' plea that he had to take in this case?
It was 1 to prison time, Department of Corrections.
Okay. That's all the questions I have for Mr.
Yes, Your Honor. Mr. Shepard, let's talk about some of those other cases first. You represented Amber Fry, correctly?
Yes.
Correct. And in your representation of Amber Fry, you came across some information that in that case, there is a confidential informant that was not properly registered by Investigator Williams, correct?
Yes, I should preface that by saying it was my firm and we all worked together on it. So, obviously, as you're well aware,
office.
Mr. Gunter. Yes, but Mr.
Yes,
Gunter was
your
was
office.
lead on that. Yes.
Yes, your office, and through the course of that investigation, your office determined or was able to figure out that that particular confidential informant was involved in 10 cases, correct?
I do not recall. My recollection was 9.
Okay, 9 or 10.
Again, that would be a question
And-
for Mr. Gunter and Mr. Sullivan.
And in fact, you currently represent that particular confidential informant, do you not?
My firm does, yes. Well, it
And that
represents her,
particular-
yes.
That particular confidential informant that was not properly registered by Investigator Williams was not the confidential informant that was involved in Mr. Sanders' case, correct?
I do not know that.
Well, your office.
I mean, Mr. Sullivan, you would know
particularly-
that, I would think.
Your office figured out the 10 cases that confidential informant was involved in, correct?
We figured, that would be a question for Mr. Gunter. I don't know the answer to that. I'm not
Mr.
trying to
Mr.
be
Shepherd, you
evasive
called-
here, but I know that there were 9 that we were able to get their sentences
After
vacated.
your office
Hold on, y'all can't talk over each other.
After your office figured it out, you personally called me to your office to have lunch to present that information to me, did you not?
Yes, sir, I did. Mhm.
And
And I just don't
you
remember
along
the
with
number,
Mr.
Mr.
Gunter-
Sullivan. I apologize.
And I'm not hung up on the number, but
Okay.
you presented the information of all of the cases that confidential informant was to me and my office at that time. Did you not?
That is my recollection. Yes, sir. Mhm. Yes.
And Mr.
Thank you.
Sanders
That's
was
correct.
not one of those. And Mr. Sanders was not one of those cases.
I remember there being 9, but I remember we had gone through and figured out everyone that particular confidential informant was involved in.
And Mr. Sanders was not one of those cases.
I do not believe so.
And ultimately, those cases that that particular confidential informant was involved in, all of those sentences got vacated.
That I believe so, to the best of my knowledge.
I've got no further questions, John.
Need a redirect?
Just one, Judge. Mr. Shepherd, knowledge of these credibility issues with Investigator Williams would have impacted Mr. Sanders' case and how you represented him, wouldn't it?
Absolutely. So I think the important thing here to realize is that Investigator Williams.
Objection, Judge, non-responsive.
Sustained.
That's fine, Mr. Shepherd. That's all the questions I have, Judge.
All right.
My question is, with the prosecutor's line of questioning, how did that help him? How did it help him to get him to admit that everyone else who Investigator Williams was a party to testifying against, all of their sentences got vacated or whatever? I would think that would not be helpful information, but maybe I'm wrong.
Mr. Shepherd, be excused.
Yes, Your Honor.
Or you may go about your day.
Thank you, Your Honor. Appreciate you.
Yes, sir. If you'll swear Mr. Sanders in, please.
solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
State your name for the record.
Edward Sanders, Jr.
Do you remember the motion that we're talking about that Mr. Shepherd argued on your behalf?
Yes,
Was it denied?
yes.
Based on this denial, what did you do?
Signed a plea,
Okay, and what were you sentenced to?
7 years.
Sometime later, you heard about Investigator William having some issues.
Yes.
And what was that you?
Credibility of the CIs and the cases that CIs have worked on.
Okay. Would you have accepted a plea had you known about these issues?
No,
Do you feel it would have been important for your attorney to know about these issues?
absolutely.
And at the time of your plea, you did not know about these issues with Investigator Williams?
Correct.
And it's your wish that the judge vacate this sentence and start your case back up?
Yes, sir.
All right, that's all the questions I have for him.
Mr. Sullivan?
No question, John, just argument.
Okay.
Just argument, Judge.
Mr. Bollinger?
Your Honor, as the state in their response, they cite Long versus State, 183 Southern Second 342, and this is basically a two-pronged test for determining post-conviction claims when there's newly discovered evidence relating to guilty pleas. The first is the evidence must not have been known by the court, party, or counsel at the time of the plea. I think we've established that. And the defendant must demonstrate a reasonable probability that but for the newly discovered evidence, the defendant would not have pled and would have insisted on going to trial. And you look at a totality of the circumstances here. Mr. Sanders' whole case was based on this confidential informant and whether that confidential informant and the investigator was truthful. An attorney such as Mr. Shepard, I know, could have went to trial on this and did really good with people who are not being truthful on things and have messed up other cases. So we feel that, had the case proceeded to trial, the truthfulness of a witness would have been a major hurdle for the state to have overcome, and that Mr. Shepard could have exploited that. We feel that the Long test has been met, and we ask that the sentence be vacated and we be set on a pretrial conference date.
Mr. Sutton?
Your Honor, I think it's important to note that the confidential informant in Mr. Sanders' case, as Mr. Shepard testified, was not the confidential informant that.
Let me just stop you
Yes.
for a moment. Would you have gone forward with this motion to suppress with this witness, knowing what you know now?
I don't know enough about the facts of Mr.
This is
Sanders'
not-
underlying
this-
case
this
and
wasn't
the
your-
basis for the motion to suppress.
This wasn't your case when it was.
It was not, Your Honor. So I don't feel comfortable answering that because I don't know enough about the basis for the motion to suppress and the arguments that were made in the motion.
Well, let me ask you, you know enough about the witness now? Not the confidential informant, but you know enough about the law enforcement officer.
Yes, Your Honor.
Would you have called him as your only witness in a motion to suppress, knowing what you know now?
No, Your Honor.
Okay. Would you have offered 7 years in prison?
Again, I don't.
I understand.
So
That's not a fair question. I would call that.
I can answer that. So out of the 10 cases that were vacated, I handled all 10 of them on resentencing.
And I'm aware of that.
And some of those cases, we worked out new plea deals. There's one that I'm prepared to go to trial on moving forward, and I'm seeking 25 plus years on. So it really is fact dependent on the case and the circumstances and that particular officer's involvement in the case.
Okay. All right, go ahead. I'm sorry. I just want.
Your Honor, the particular CI that was used was not the issue. It was not the CI that Investigator Williams did not properly register. And the rationale, the basis for vacating those 10 sentences was not due to any credibility issues that Mr. Shepard claims that this officer has. The basis for vacating those 10 pleas was because there was a confidential informant that wasn't properly utilized. And our office felt that that was Brady material that should have been disclosed prior to any of those defendants using or entering pleas or going to trial. Our office was not aware of that information until after those sentences were, or those pleas were had, or those trials were concluded. So at that point, we felt that was Brady material that could have played a role in negotiations. That was the basis for vacating those sentences. The argument that this would have changed the defendant's position on taking a plea or not is tenuous, Judge. So if you take the defense argument that this officer has credibility issues because of an issue with this CI over here, moving forward with trial, that internal investigation involving that other CI would not be admissible in Mr. Sanders' trial because it does not involve that particular case. There's case law that is clear. Florida law is well settled that officers' internal affairs investigations are only relevant to the cases that those internal affairs investigations touch. So the fact that he had this CI that wasn't properly registered and misused that CI would not be admissible. It would not be relevant to Mr. Sanders' case, and it shouldn't be taken into consideration whether that would have affected his choice to move forward or not.
Okay. All right, anything else?
No, Your Honor.
I'll take it under advisement. We'll go ahead and Mr. Sanders will be transported back to the OC. If there is a change in that, we'll bring him back. Okay?
Thank you,
We won't
Judge.
set another
That's all I
court
have.
date until we have an order.
Thank you, Judge.
All right. Mr. Sling, let's go ahead and I've got Dr. Schuler and Dr. Dorica. They're in the Zoom rooms. Mr. Brown is out.
Yes, Your Honor. He just came in, I see. Judge approaching is Cody Brown, as you know, in case number 23-4512. We are here for a competency hearing. As the court knows, we do have both of the experts on Zoom. Both of them have issued reports which have been filed with the clerk, the court, as well as a copy given to the state.
All right.
So this is a competency review. And it gets interesting.
And let's see, who wants to call? Mr. Lane, you want to call the witnesses?
Yes, that's fine, Your Honor. I see Dr. DeRico on the screen, so.
And Dr. Schiller's also, she was.
Just the video's off,
She was
okay.
on there anyway. Ms. Nelson, is Dr. Schiller still in the Zoom room?
I'm here.
Okay, very good. All right, you can call your first witness, Mr.
All right, thank you. I guess we'll go with Dr. DeRico, since he was on the screen.
All right, Dr. DeRico, raise your right hand.
Or we could do Dr. Schuler. I don't care, since she's on the screen now. It doesn't matter to me. That's fine.
All right, Dr. Schiller, raise your right hand, please.
She can hear us. There we go.
solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Dr. Schuler, are you able to hear me okay?
Yes.
Okay, so this is Al Saline. I'm here with my client, Cody Brown. It's my understanding that you had an opportunity to conduct an evaluation of Cody Brown earlier this year. Is that correct?
Yes, it was in April.
And following that evaluation, you issued a report. Is that also correct?
Yes.
Okay. Explain to the court your general finding as far as whether you found Mr. Brown competent to proceed or incompetent to proceed.
Just by way of background, I was the second evaluator. Dr. DeRico did the first evaluation. I did notice some differences between his evaluation and mine, although they were slight.
Okay. Tell us about those.
Basically what this came down to is during the evaluation with Mr. Brown, the primary difference was that he reported to me that he had quit taking his medication against the advice of his medical provider. And so I noticed that he seemed to have some increase in paranoia. He reported some increase in symptoms of depression. He stated to me that upon coming into jail, he was experiencing hallucinations and delusions. Now, he did not present that way during this evaluation. I suspect that may have something to do with he had not been off of his medication all that long at that point. He did talk a lot and perseverated upon somatic complaints, which is physical concerns, his medical issues, to the point that it was very difficult for me to redirect him to topic. So obviously, when someone tells me that they stopped their medication against medical advice, that decision and the potential consequences of that decision is really not something an evaluator can ignore. So because I saw this increase in symptoms, my concern was that there would be further increase in those symptoms. I noted on a couple of the areas that his presentation was questionable. I did not find him to be rated unacceptable outright on any area. It was mostly disclosing facts to his attorney and testifying relevantly, because he just had a very difficult time staying on topic. He was hyper focused on his somatic complaints, and almost to the point of paranoia, in the sense that he was accusing, jail of conspiring to not treat him. It was beyond just not feeling like he was receiving adequate care. And so I did come down on the side of incompetency. I don't know why that's on the screen. There's something, I don't know. Am I still on here?
Okay.
Yes, ma'am.
We hear you. We just can't see you, Dr. Schroller. I
Okay.
apologize for speaking over you. I didn't see your mouth moving because I can no longer see you. I thought you had.
You're okay. There's just something over the screen.
Yes, ma'am.
Okay.
Still hear you.
So just to wrap this up, I came down on the side of incompetency because he had quit taking his medication. I saw some increase in symptoms. I thought that the most prudent course of action in the, interest of being cautious was to have him referred for jail-based competency services in the hopes that he could get back on his medicine and, continue on. And because obviously my concern was that if he continued to decompensate, that may result in a more serious situation. He may have to go to the state hospital. I was thinking that was my thought process.
Yes, ma'am. So the end result, you agree that he is incompetent to proceed. And basically your recommendation is that he remain in the jail and be treated by life management, not to be sent to Florida State Hospital in Chattahoochee. I see that in your report. I'm just confirming that.
Yes,
Still
that
your
was my
recommendation.
that was my recommendation.
They said it was optional the first time from life management when I saw the psychiatrist. I've seen 2 psychiatrists since then, and they said that I don't need them using coping skills, that would do it. When it comes to the injury,
And while Mr. Slane's having a conversation with his client, I
Yes,
don't
sir.
see that Dr. Schiller's report's in the court file. Am I missing it?
It should have been filed, Your Honor, but I have a copy right here. If I may approach, I can.
And I may have one in my office. I don't know, but let me review it while you're doing that.
Yes, Your Honor.
And looks like Dr. Rica's is in there twice.
and they said, hey, you can.
Can I add something?
Yes, ma'am.
I did want to know that he had not been off his medication all that long when I saw him, and it was, over 30 days ago. So, I don't have any way to know at this point how that worked
Dr.
out. For
Schiller.
him. Mhm.
And Dr. Schiller, this is Al Saltling again. Did anyone ever inform you that life management initially told Mr. Brown that his medications were optional? Or is it your understanding they were required to be taken?
Nobody told me that. Typically, in my experience, if a doctor prescribes medication, they do it because they think someone needs it. It's, that.
Yes, ma'am.
If it's optional, I would think that they could come back and get a prescription at a later time.
Yes,
But
ma'am.
nobody told me that, no.
Okay.
Mr. Sullivan?
No questions, Your Honor.
All right. And Dr. Schiller be excused?
Yes, Your Honor, as far as I'm concerned.
Dr. Schiller, you can be excused. Thank you for your assistance this morning.
Thank you.
Dr. Dorico, if you'll turn your video on. Good morning.
Morning. Now keep in mind, she was the second evaluator. So this guy would be the first.
Madam Clerk, just swear Dr. Dorico in, please.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Sling, you may inquire.
Thank you. Dr. Dorico, are you able to hear me okay?
Yes, sir.
Okay. All right, doctor. This is Al Saline. I represent Cody Brown, who is standing here next to me. It's my understanding earlier this year you had an opportunity to conduct an evaluation of Mr. Brown. Is that correct?
Yes, sir. It was January 30th, 2024.
Okay. And it's my understanding that upon conducting the evaluation, you also had concluded that Mr. Brown is incompetent as of that time. Is that correct?
No, I said he was competent.
Okay. Apologize, I misspoke. Explain to me why you felt as though he was competent to proceed in light of the fact that Dr. Schuler found him incompetent to proceed. There was actually a family therapist who had also believed he was incompetent to proceed. My apologies for misspeaking, but go ahead, doctor.
Well, I talked to him before Dr. Schuler did
probably about 3 months before Dr. Schuler got to him. And at that time, you know, he seemed to be competent for trial to me. I mean, he said he wasn't having any problems with psychiatric symptoms, wasn't having hallucinations, didn't make any delusional sounding statements. I got his medical records, and you know, there was Thorazine prescribed for him, but at the time I talked to him, for like 2 weeks before, well, maybe more than that. Let's see. Like for the first 3 weeks of January, he's been refusing to take his Thorazine. And when I was talking to him, he seemed to be perfectly stable. You know, he didn't have any, he could remember, you know, historical information. He was courteous, polite, you know, well behaved. He denied, he said that he might have had sleep apnea and he might have had a possible head injury, but that was like over 2 years before the current evaluation. I mean, the evaluation I did in January, and he wasn't, I mean, you know, his memory, his ability to abstract thought, his ability to do mathematical computations were all in the average range. So, I mean, frankly, I didn't see anything wrong with him.
Okay, you mentioned in your recommendations aftercare medical evaluation and possible neuropsychological rehabilitation treatment. So that
Right.
had only the brain hemorrhage issue, nothing to do with competency concerns.
Right.
Okay. And I know that we've had individuals in the past that you've evaluated and periodically found that they may have been faking to have a problem. In this circumstance, I'll ask the question the opposite way. You do not believe that Mr. Brown was faking to be more competent than what he may be as a matter of pride or that sort of thing. You know, sometimes people will deny the issues they have.
That's a question like, that is a question sort of like saying that someone can fake good on an intelligence test. There's no way you can fake good on an intelligence test. And there's no way you can
And
really
you feel the
fake
same
good.
way.
Yeah. So, I mean, I thought he was being straightforward with me.
Okay. Yes, sir. Judge, I don't believe I have any other questions at this time.
No question, John.
All right, thank you, Dr. DeRico. Have a good day.
All right. Thank you so much, Judge. You have a good one too.
Yes, sir.
Bye-bye.
All right. Argument?
Would you like the defense to go first? Okay. Judge, in light of the two reports, normally I would look to the one that is more recent in time. In this circumstance, there is a multiple month time period differential between the two evaluations. Knowing his lifetime history of mental health issues, including even now, I do have concern in speaking with him whether or not he truly is ready to proceed. Alternatively, with the two conflicting reports, the defense has no objection if the court were to appoint a third individual to conduct an evaluation as permitted under Florida law. But given the choice of the two, I would defer to the one that was more recent in time, especially if there's a question about taking medication or refusal to take medication.
So I did the proper steps in regard to him. I was missing my son, so I was about to really taught me coping skills to go around it. The hallucinations were due to the head injury, the knee to the back of the head. It could be felt. It's been seen by the medical staff at the jail.
Your Honor, my client just wanted me to point out to the court that some of the medication was not for competency. He believes it was more for depression, and that issues with the back of his head were from the underlying alleged incident or being taken into custody. Not that that necessarily changes the testimony of Dr. DeRico or Dr. Schuler, but that is what Mr. Brown asked for me to place on the record for you, Judge. My apologies for the interruption.
Oh,
Your Honor, the state takes no position as far as the competency issue goes at this point.
Probably what the best thing to do is to find him incompetent this time. Go ahead and have a status review, and I'm gonna have the status review on July. What is my motion day in July? July 19th at 9 o'clock. Go ahead and find that he's incompetent. Proceed that he does not meet the criteria for hospitalization. And what I'm going to do is go ahead and have life management set up a treatment plan. If they make a determination that he does not, that he does not, there's no other restoration that's needed.
Yes, sir.
That he's been off his, if he's off his medication, that he has not gone any farther.
Yes, sir.
And, I'm prepared to go ahead and find him competent at that time and go ahead and proceed with the case. Is everyone in agreement with that, or have any objection to doing that?
No objection, Your Honor.
All right,
No,
let's
Your
do
Honor.
that. And Mr. Saline, if you'll prepare an order.
Yes, sir.
To that effect.
Yes, sir.
And then we'll do that. I'm gonna give this back to you. If you'll make sure there's a report filed.
Yes, sir.
Filed with Dr.
I will
Schuler's
get it
report.
filed.
And Mr. Brown, what we'll do is we'll get that opportunity. And if you are competent to proceed, we'll proceed on, okay?
Yes, sir.
All right. Anything else?
No, Your Honor.
All right, that'll conclude the hearing.
Sounds like he's erring on the side of caution. Probably a good choice.
Management. So that might be a third option, because that's one option that's on the table.
Judge, we do have the no contact motion that I believe was also scheduled for today, if the court would like
Is there
to.
any objection to that?
And there are some family members here if necessary to testify, but
If you want to have a chance to speak with I guess it's the ones who are asking for the contact.
Mr. Shawing, which witnesses are you seeking contact with?
I can pull the motion. Mr. Sullivan, if you give me one moment, I was just trying to put the file back together. The individuals that were listed in the motion, the most recent motion.
I see here. The state has no objection. Your Honor.
Okay.
All right. And I'll grant the motion may allow only peaceful contact.
And Your Honor, would you like me to send an order reflecting that as well? Okay, so two different orders. Yes, sir. Will do.
Stogel's got a bond motion. Mr. Manuel?
Okay.
Jacob Manuel. All right, he's here in 23 CF 1317. His bond is currently set he basically has a 7-count information. It's set as $250,000 in count 1, 500,000 count 2, 250,000 count 3, 500,000 count 4, and then counts 5 and 6 are 15,000 and 5,000 and count 7. If I could have Mr. Manuel sworn in.
Ma'am, Madam Clerk.
Tell me swear testimony you're about to tell the truth, the whole truth, and nothing but the truth, so help you God.
Do.
All right, Mr. Manuel, prior to coming into custody, what job did you hold?
I was a CNA nursing home,
And where was that at?
Knoxville, Tennessee.
Okay, and were you living down here in Panama City, Florida?
I was.
And where were you living?
I was living off of
Okay, and were you employed down here?
I was.
And what is the actual location of your employment?
I was employed at No Name Lounge.
Okay. All right. And your bond is currently set just over 1.5 million, correct?
Yes.
Do you or your family have any ability to meet that bond?
Absolutely not.
Okay. Is there any bond that you could?
Somewhere close to 250.
Okay. You're nothing further.
Thank you. Thank you, Ms. Nelson. Thank you. Mr. Graham, any questions?
One, when you were arrested on this, did they have to extradite you back from Knoxville, Tennessee? No further questions.
All right, Ms. Jewell?
Your Honor, basically in this case, the bond is currently set at 1.5 million and some change there. Your Honor, these bonds especially count, I would say 2 and 3 or 4 are both $500,000 apiece. Your Honor, would ask for bonds more in the neighborhood of $50,000 per count on those 4.
Mr. Graham?
Judge, one of the things the court can look at is the strength of the case. The defendant, the facts in this case are extremely strong for the state, and I feel like conviction, there's a very strong chance. There were 2 victims killed, Miss Ellis and Miss Hughes, and a 10-year-old girl was severely injured. The defendant hit the victims from behind, going anywhere from 100 to 131 miles an hour. There was no evidence of braking on the electric data recorder. It also indicated that the defendant accelerated. His legal blood alcohol 3 hours and 23 minutes after was an 09. His medical blood draw, which was about an hour after the crash, was a 19, which I think would convert to about a 16. And he also had amphetamines, barbiturates, cannabis, cocaine, and opiates in his system. This score sheet, Judge, has a minimum of 24.75 years to a maximum of 40 years. We'd ask the bonds remain as they are.
I've reviewed the file, the probable cause affidavit. I also reviewed, I think the bench warrant was issued, was it almost a year, 11 months after the alleged incident? Is that correct?
I think so.
What I'm going to do, I understand Judge Rester's first appearance, but what I'm going to do as far as the $250,000 bonds, I'm going to lower those to $100,000 a piece. Those are on counts. Those are the count DUI manslaughter. There's 2 DUI manslaughter and
2 vehicular homicides. Counts 1 and 2 are the 2 DUI manslaughters. Counts 3 and 4 are the vehicular homicides.
And I'll leave the rest as they are. What's that total?
Your Honor, counts 2 and 4 were both $500,000 bonds.
I did not see those on the first appearance document. I mean, yeah. Oh, here it is. I've got it. And I'll lower those to $250,000 a piece.
Thank you, Your Honor.
The same conditions that he'll submit to, if they're not on there based on this, I am going to, based on the fact that I've reduced those bonds, he'll be subject to random UAs, random breathalyzer while out on bond. He's not to operate a motor vehicle while on bond. He's not to possess or consume any alcoholic beverages while on release. He's not to possess or consume any controlled substance not prescribed by a treating physician. Do we need another court date?
He was on the 9-brief trial document, but there was a motion to continue.
Okay. Any objection?
Well, I was the one who made the contention. I want to be actually.
So he doesn't object.
Any objection?
So Judge, there is a September 30th trial date, if that's good with Miss Jewell.
Yeah.
The September 30th, that I think that's a special trial week, which usually
I think that's going to be my regular trial week. So we could set it.
Okay.
I haven't told anybody yet, but that's what I'm considering.
Madam Clerk, what does that make as bond total? I couldn't keep up with the math. I'm an FSU graduate.
That's one.
I was told there would be no math. It's 5, 6, 7, 35, I think. Is that right?
It would be a reduction of 500, 800, correct? On the,
Where did you see 500,000?
this is Judge Van's first appearance docket. That's the
It was on
DUI.
counts 2 and 4,
That's the
500,000. Counts 1 and 3 were 250,000.
He was first appeared by Judge Rester and Judge Van.
250,000, 100,000, and 500, 200.
Correct.
And the rest of them remain.
And I'm gonna set the trial for September 30th. We'll set it for a trial management August. Okay. All right. That'll conclude that hearing.
I don't think they ever actually gave the final number. I think they just gave up mathing. And as far as why bond, sometimes the judges have no choice. Some cases, some charges, they're required to give the defendant a bond. There are certain instances where they can do like no bond hold and things like that, but apparently this wasn't one of them. But they can make it an unaffordable bond, which was what originally was done. And even the reduction is still an unaffordable bond based on the defendant saying that he could afford $250,000. So it's still an unaffordable bond. It's still going to hold him in there. I thought you might like Judge Brantley. I know you're a tough nut to crack. You're someone that's hard to keep happy around here. But you had Judge Sylvester, and even though he has long hair, he had it in a nice little ponytail today, and he wears a robe, and he's very sweet, you know. And we had the female judge from Arizona, Judge Wade Mercer. He's always very professional looking. I think I picked a very good Patrick B. pleasing judge docket. I agree with you. Yep. Everybody, well, people who've been here a long time, they know. They know my story of my hatred for DUIs, because when I was about 10 years old, we lost a very, very close family friend. I might have even been younger than 10. I was young. I was way too young to even like figure out what that meant to lose him. But a very close friend of my brother's, his best friend, was walking his moped home after work. He was a teenager, y'all, and he was walking his moped home, and a drunk driver hit him. His shoes were at the point of impact, and he was 55 feet in a ditch. The guy then went home, and an hour and a half later, called the cops and said, "I think I hit something on Coney A." And, yeah, he waited an hour and a half because he told the cops he wasn't sure what he hit, and it scared him. So he went home and drank a six-pack, sorry. Yeah, I'm fired up. Can't even speak. Yeah. Yeah, so after quite a while in the hospital, he passed. And he's the reason why I don't drink and drive. Thank you, Patrick B. I love having you here. You're a good buddy. Kinda, yeah. It's fun. Yeah, it's hard. It's really hard sometimes to see the justification and the logic, and sometimes it feels like the defendants have more rights than the victims, and that's so painful to see. Yeah. Yeah, they have to balance that with protecting the public. But then there's instances like, Darrell Brooks, who he never should have been out in the first place. Absolutely. He should not have been out in the first place. He wasn't supposed to be out. And look what happened when he was. Yeah. Yeah. If you don't like it, vote different. Petition your legislature. It all changes with the lawmakers. Yeah, I'm sorry, sweetie. It's really hard to watch. There's been a couple of times where I've had to go off camera just simply to hide my face because I couldn't on some cases that I've seen because it hit so close to home. It was, very painful. Oh, we will, crazy old Rexy. We have 4 minutes until it starts here. I am gonna go. I wanna go into Discord for at least a little bit, but I am tired. And I have not been sleeping very much. And I spent literally all day looking at the screen. That's not an exaggeration. I wish it was. But all of that's from yesterday. Or Friday. All of that stuff was from Friday. I went down, literally just went down my everything downloaded from Friday. And, I wanted to stay in the first appearance realm of things. Because originally I had a theme idea. And then it just kind of became a hodgepodge. I love hodgepodges, though. They worked out. Because those Brantley cases, those were so interesting. I couldn't resist. I'm like, nope, I have to show these. Thank you for showing up for the live, Patrick B. I really appreciate you. You are, like I said, you're a great buddy. You are a fantastic supporter. And I'm so grateful to have you. And I love our little conversations that we have. You're always so much fun. No, I think they should get the same treatment that my cats got. My cats didn't do anything wrong. Thank you for that, Joey Bag of Donuts. Half staff, sunrise to noon. Full staff, noon to sundown. Don't forget your light. Thanks for coming, Nana Laura. I love you so much. And crazy old Rexy, my sweet, sweet, wonderful friend. You mean the world to me. No, I said I would go into Discord a little bit. And it's spellcast, not spell chat. I can already see I have a leg up on you. It's a spelling game, like Boggle, y'all. And she can't even spell that right. No, she's actually quite the opponent. She just takes forever. I also really, really love Yahtzee. Love Yahtzee. And I'm trying to figure out a way maybe I shouldn't tip my hand on this, but I want to do a members only stream. What I want to do is I want to, you know how I can share my screen? I want to go into Discord and be playing the games with you guys and share it here. And we're testing it out. We're going to see if it works. But that way, if you want to, be in Discord and be challenging me, you can. But for those who just want to watch and cheer along and joke around, you can do that in the chat and watch the game. And I think it would be a lot of fun. I think it really would be. So that's the next project. It's the goal. I'm going to try. Of course we can. The best way to say goodbye is with bacon. That did not take long. I just grabbed the bag and then look at this. Look at this. Her little head was there. Her little head was right there. She knew. She just popped up. Kiss. All right. Wait. I know. It's bacon. Wait. You can get the fluff off my desk. Okay. Straining a little hard there, huh? Yeah, here you go. Oh, you're drooling everywhere. You're so lucky Palmy loves you. Otherwise, he would be giving me all kinds of heck about all the dog drool on my desk. But no, because it's Ava. It's okay. Hi, Mel. Mel, thank you so much for coming. We're on the Spoil Ava part of the night. I really hope y'all come on over to Discord and play with us tonight. People have not been coming. And it's so much fun in there. And it's voice chat. You don't have to talk if you don't want to. But it's so hilarious. I've just been sitting here crumbling these. It's only 3 strips. I know it looks like it's so much more, but it's been only 3 strips. She's so happy about it. Oh, there you go. Now, lick up the crumbs and your slobber. Oh, no, you're going to just leave your slobber with me. That's why I have 2 jugs of this here. I think I have a green jug of it in the kitchen, too, just in case I run out of these. Oh, yeah, I've not been doing that lately. Yeah. Well, unless you count the times that I've, fallen asleep in places I should not be falling asleep. Like leaning over my handicap railing or, I will not claim. You know what? I'm just going to stop there, or I'm going to say something that's going to really embarrass myself. Oh. You know what? Patrick and Emily, they are the absolute most wonderful people for helping get you acquainted with it. I'm not kidding you there. I am not Patrick. Oh my gosh. Sir Philip Heels. Somebody quick, erase that. Erase that part. Just once or 20 times. But then I was talking to Lone Wolf Soul, and he made me feel all kinds of better about it because he's like, oh, I was known for that. Oh, yes. Yes, everyone. Say prayers. Absolutely. Alley Cat, honey. Hi, sweetie. I was just wrapping things up. I usually pop right back up though. Usually. And you don't know how many times Emily's texted me. She's been like, "Are you awake?" And it's like, yeah, I'm just sitting here watching it. But I know my eyes are like really squinty, so it's hard to tell on that tiny little thumbnail in the bottom. But and it's only okay. Here's the thing: like when I'm interacting with you and talking with you, and we're joking around, wide awake, absolutely wide awake. But then when we start watching the cases, and it's cases that I've already seen 3 times because, you know, I watched most of it when I was determining whether or not I was going to stream it. And then I watched it while I added it. And, you know, now I'm watching it when I'm playing it. You know, I've already seen it. It's just, so sometimes it's just like, oh, you know, as it's running. And I've been up for, you know, since 5 a.m., 4 a.m. You know, it's about time Ava wakes me up to take her out to go potty and then feed her. And then I gotta, you know, I sometimes gotta lay back down, and I don't get to because I get occupied, muy ocupado. So I just, yeah. Sometimes you just zone out. And I'm waiting for a spot to say something because, you know, or waiting for a hearing to conclude. And, whoa, you know. Oh, I've done that so many times. Oh, so many times. Yeah, but you're not on camera when you do it. I loves you too. I'm actually going to go over to Discord and we're going to play Spellcast or Yahtzee or Checkers or something like that. We're going to have some fun playing some games. And then we'll see from there. I know you guys are like the ride or die kind of love. Y'all are with me whether I doze off or not. I really try not to. I really, really try not to. Because it's super embarrassing. Yeah, it is now renamed as Spell Chat. Oh, ever since I started it, I dream of 4 hours. Hey, there's naps. There's sleeping at my desk and stuff like that. I don't do that. You're not wrong. You're wrong on what it is, on what it's called, but you're not wrong on that. Hi, Papa Les. I love you. Well, that was before you became one of the cool kids. All right, guys. I have to go. Be safe, be well, sleep sweet, and much love.